Morning.
Good morning.
Morning.
Good morning. We have two cases set for argument this morning. The first case we have is case number C200381, Jerry Ray, Director of Ohio Department of Transportation versus Albee Holdings PLL et al. If attorneys can please identify themselves and their readiness to proceed.
This is Sean Callan from Manley Burke on behalf of the appellants, Business Information Solutions and Albee Holdings, and we are ready to proceed.
Thank you.
Thank you, Your Honor. My name is Martine Cordero. I'm an Assistant Attorney General. With me present in the room is Assistant Attorney General Corinna Efkeman and Assistant Attorney General Justine Allen, ready to proceed on behalf of the Director of Transportation.
And Attorney Cordero, will you be the only one arguing this morning?
Yes, ma'am.
Okay, thank you. Attorney Callan, whenever you're ready, and would you like to reserve time?
Yes, please, Your Honor. I'd like 5 minutes for rebuttal.
All right, whenever you're ready.
Thank you. May it please the court. The issues before you today relate to only one of the appellants, and that is Business Information Solutions, or as I call it, BIZ. BIZ is the operating entity that was housed within the building and property that was subject to the taking below. So it's the operating entity. It is a commercial record storage center. To give you a sense of where this property is, if you ever drive on I-75 north of downtown, you've probably seen this building. It's off to the west of I-75 on Spring Grove Avenue. It's very close to downtown. But in any event, BIZ is before you today seeking limited relief. And specifically, what BIZ is asking the court to do is remand this case back to the trial court for further consideration, but applying a proper standard of review. It is our contention that the trial court here applied an improper standard of review. Specifically, under the trial court standard, BIZ was required to make a demonstration that the expenses at issue in this case were somehow, quote, necessary, whatever that may mean. And BIZ further contends that the application of that improper standard resulted in an unfair result. And looking at this case, fundamentally, this case is about fairness. As I'll talk about, these are remedial statutes at issue. But any examination of fairness begins with an evaluation of the relative positions of these parties. I mean, here you have on the one hand, ODOT, a state agency with all the power and resources that come with being a state agency, coming into Cincinnati and laying claim to a piece of property. And then 5 years later say, wait a minute, we don't even want that piece of property. Just forget it, you keep it, go about your business. On the other hand, you have a small family-owned Cincinnati business, a business with a small but long tenured workforce, a workforce that is characterized by employees with decades of experience and tenure, a business that operated for some 30 odd years on Spring Grove Avenue without interruption until ODOT arrived on the scene. And once ODOT arrived on the scene, BIZ was forced into an unwilling relationship with ODOT that lasted for 5 years. As we lay out in our brief, that relationship was long, it was unpleasant. In fact, it was extremely unpleasant. Beginning in 2014, when ODOT first contacted this company, ODOT created an environment where BIZ constantly faced an uncertain, unknown, and seemingly changing future for a period of 5 years. So questions of fairness permeate. Yes.
Do you have issue with the court's determination that it need be necessary, and or the court's determination that it need to be within the presentation of the case?
Well, both, Your Honor. If you look at what the statutes actually say, let me skip ahead here a bit. The statutes actually contemplate a showing of an other actual expense is contemplated by 163.21, and that was incurred because of ODOT's actions is contemplated by 16362. And that is what the statutes say. They do not say that the expense must be necessary for any particular purpose, and they certainly don't say that the expense must be necessary for the presentation of the case to the jury. To that point, the Ohio Supreme Court has told us many, many times that courts should give effect to the statutes as written and not delete words used or to insert words not used.
So what should we do with the cases that have interpreted the word just within the statute to mean reasonable and necessary?
Well, as far as I'm aware, the only case that has decided that under 163.21 that an expense must be necessary for the presentation of the case to the jury is a triplet case out of the 10th district.
Well, I'm just talking about reasonable and necessary.
But
Which
necessary.
goes back to my first question about whether you have an objection with necessary and or presentation of the case. So I'm just talking about reasonable, necessary.
Let me answer it in a different way. I do think that inherent in any question of recovery under any statute or any legal theory, there has to be some concern with causation. So that would go to your question about, just and necessary. Now, I think here, if you look at the time frame within which this expense first accrued, it was in December of 2016. The facts of the case that predate that, again, start with the May 22nd, 2014 email from Mr. Rader's ODOT project manager to Mr. Albee, Frank Albee, the owner of this company. Mr. Rader's told Mr. Albee at that time that your property will be needed. And at this point, it is planned to be a total take. Your property is a priority parcel. It may be in your best interest to move and reestablish as soon as possible, simply to keep your business operational with the least amount of downtime. Now, after that email, all communications with ODOT contemplated a complete take. So that was the framework within which BIZ was operating between 2014 and then 2017 when ODOT changed its mind. But at the time that this employee retention policy was adopted, it was in 2016, late 2016, and the framework within which BIZ was operating was based on ODOT's representation that this was a total take situation. Now, importantly, BIZ could not move without these employees. I spent some time in the brief to sort of explain how complicated this business is. We're talking about hundreds of thousands of boxes with barcode addresses kept according to a proprietary system within BIZ that all of these employees were trained on and knew. So literally, BIZ could not comply with ODOT's requirement that it move without keeping these employees. So it was important to BIZ not to keep the employees strictly for a business operational sense, but it was very important for BIZ to keep these employees in order to move. So in that sense, this policy was a direct result of ODOT's telling BIZ starting in 2014, you're going to have to move. So from
that's not in dispute though, right? There were proffered facts in this case, and the trial court accepted the fact that this policy was in fact put in place because of the move.
I'm not sure. I'm not sure the trial court did that. I can't tell exactly what the trial court did here. I do know that the trial court, in its determination, added the word necessary to a statute that doesn't require a showing of necessary. I know that these statutes are remedial in nature. And the idea of a remedial system is to arrive at some kind of fair result. And the Ohio Supreme Court has told us that a liberal construction of a statute requires that every reasonable presumption in favor of the benefited party be indulged, and importantly, every doubt be resolved in favor of the party benefited by the liberal construction. And that certainly didn't happen here. In the decision below, the trial court gave a nod to the idea that these were remedial statutes. I mean, it says in the decision, these are remedial statutes. But certainly the trial court did not resolve all doubts in favor of Biz. Instead, the trial court...
Sorry to interrupt. I'm having a hard time understanding what you're asking us to do, because you started off by saying that there was an improper standard applied by the trial court, and you want a remand.
Yes.
Isn't this really just a question of statutory interpretation that this court can do, right?
Yes.
And we reviewed de novo whether the trial court was correct in determining whether these expenses are covered under the statute.
Yeah, that's a great question, Judge Krause. And I think the reason I'm asking for a remand is because we didn't have a factual determination below. We had no evidentiary hearing. All we have are some proffered facts. So,
but I thought the parties agreed to that. I thought the parties agreed to allow the trial judge to interpret this statute based on a set of proffered facts, of which, as going to my original thing, the court said, due to the complexity of the anticipated move, defendants feared losing skilled employees. As such, in 2016, they promised to pay employees retention bonuses. So that's not disputed. And then based on that, there's a statutory interpretation issue, right?
That's true. And I suppose that this court could make a determination on a de novo review that if the facts are in the proffer are proven, that Biz would be entitled to recovery. But I think ODOT would not agree that the proffered facts are agreed between the parties. Those were just proffered facts of what we anticipated we would be able to prove at an evidentiary hearing. So I think probably this has to go back for a factual evidentiary hearing, whatever the court may decide here. So I think that's why I'm asking for remand instead of just judgment in our favor. I don't think the case below is ready for that.
So it would go back if we ruled against you, it would go back?
Well, no. I mean, if
you said whatever we decide.
Yeah. Well, okay. Whatever favorable decision you might make for appellants.
Okay.
Thank you, Attorney Callan. I'm going to reserve your 5 minutes.
Thank you, Judge.
Good morning again, Attorney Cordero.
Good morning, Your Honor. Hopefully you'll be able to hear me. The short answer here is $215,000 of an employee retention bonus is no way, shape, or form either an other actual expense under the abandonment statute or an expense, a disbursement, or reimbursement under the displacement statute. And the reason we can see this is, let's go back to the abandonment statute. It lays out 3 instances where fees are to be paid: witness fees, attorney's fees, and other actual expenses, right? And when we look at that, when you look at other actual expenses, the word other suggests that you have to look at A and B. If I say I'm going to the store to buy milk and bread and other things, I'm not walking home with the chainsaw under my arm, right? I'm walking home with something that's related to those first 2 things. And that's assuming that we agree that the statute is unambiguous. We don't believe it's ambiguous, but let's assume that it's not ambiguous. Other actual expenses has to be related to A and B. A and B are litigation expenses. If this court were to believe that the statute is ambiguous, statutory construction tells us that you have to look at things in the list, A and B again. So again, we're circling back to litigation expenses. Other actual expenses does not mean what the appellant wants it to mean, which is any expense. It's other actual expenses. And part of the problem here is that what we're looking at is an objective standard statute, not a subjective standard statute like the appellants ask you to do, but an objective standard. Because
if it was other related expenses, wouldn't the legislature say other similar actual expenses or other related actual expenses?
I don't think that it needs to. The word other in and of itself suggests other actual expenses. It's connected, just the word other. It could have used, if it wants to adopt the landowner's opinion, it could have used any actual expenses. It could have removed the word other. It could have just said actual expenses. So part of the problem here is when we
Well,
look at,
that would make sense in light of witness, first, the statute talks about costs. So it addresses costs separately before it goes into this enumerated list of 3 items.
correct,
The enumerated list of 3 items are attached to incurred by the owner.
correct, because costs is followed by including jury fees. So I think that costs were court costs, right? And so then the enumerated list are the things that the landowner would experience: witness fees, including the experts, attorney's fees, and then other actual costs that would
Right,
presumably.
but it's going back to incurred by the owner, and the incurrence is based on abandonment.
That's correct, Your Honor, but it has to be an objective standard. If I'm advising my client to abandon this case, I can give them an approximation of what a witness fee will be because I'll have gotten reports. I might even gotten an itemization from that expert. I can guesstimate how much the attorney's fees are, but the statute would never have suggested other actual expenses that I could never discover, right? Because I have no mechanism under the civil rules to take the deposition of the owner of BIS and say, give me your employee salary list because my client may want to.
Doesn't that go to, courts have interpreted just to mean reasonable and necessary. So doesn't that then limit those other actual expenses to that which the court would determine to be reasonable and necessary?
Correct, Your Honor. But what I'm suggesting to you is that when we look at the way the courts have interpreted it, we're looking at interpreting reasonable and just as related to the case, not as related to the actions of the owner. That's why I keep circling back to litigation expenses.
Well, the case only arises because of the abandonment. Because of the taking, the potential taking. But for the potential taking, then it wouldn't have been incurred. Again, the language incurred goes to the fact that there was a potential taking that was ultimately abandoned. So we're not talking about owner decides to go on vacation. I think that's pretty clear on the statute.
But how, Your Honor? Because you could turn the facts around to say that if Mr. Albee decided to cancel a vacation and incurred a fee for cancellation because of the condemnation, he wouldn't have had to stay in Hamilton County. That's why the last part of the rule.
But again, doesn't that go to the whether it's reasonable and necessary?
And that's why I think that when you look at the way it's been applied, whether you look at the Sellers, which was ODNR versus Sellers originally discussing, it talked about costs that were costs, expenses, and attorney's fees. In fact, the statute at the time said reimburse the owner for costs and expenses in the conduct of the proceeding. 30 years later, Columbus versus Triplett picks up on that language and says reasonably necessary for the presentation of the case. And I know the Landowners Council got all twisted with the words reasonable or necessary. Take them out. Just simply say other actual costs in connection with the case. Those things are not unreasonable.
I do have that statute in front of me.
Yes.
2709.24, and the predecessor to that as well, which is the one that was in place at 1918 at the time of the case that you're citing from within Sellers. So in both statutes, the language actually says the judge shall enter judgment against the corporation and in favor of the party entitled to such payment for such amount of expenses, including time spent in attorney's fees incurred by him in the proceeding. So the in the proceeding goes to attorney's fees and so on, but expenses is separate in that statute.
Correct, Your Honor, but I don't think the
The
legislature.
proceedings doesn't go to expenses.
I understand, Your Honor, but I don't think the legislature would have ever drafted a statute that had no boundaries. Here, the way the courts have interpreted it are that we are bound by those expenses incurred by the owner as part of their case, right? It's the litigation expenses. To give you an example, when we cited Wayne Lakes, we talked about testing of the water. In other cases, when we have gas stations, we're looking at soil contamination. In agricultural cases, we're talking about tillable versus not tillable, ground. If we're talking about timbered ground, we're talking about getting an inventory from the landowner of how many trees, what sizes are, and how much board feet are we acquiring. Those are the types of expenses that we can reasonably anticipate that if my client elects to abandon, has to face. But all of a sudden to say that my client has to think somehow that this landowner has given away a retirement bonus, right? We're originally talking about a $200,000 deposit for half
Again,
of
your argument goes to reasonable and necessary,
correct, Your Honor, and that's why we believe that this
which ultimately that would have to be determined by the trier of fact. That wouldn't be for us to determine whether an expense incurred by, because the incurred by the owner has already been proffered.
correct, Your Honor, but I think that this court in the statutory interpretation can say that it's incurred by the owner, not just willy-nilly because they chose so, but incurred as part of the proceeding, incurred as part of the litigation, incurred as part of that thing which we reasonably could anticipate we would have to pay. The only way we would
Well, what's
ever
interesting about your argument is this. So you're saying incurred in the proceeding, the abandonment can take place before the proceedings are, any court proceedings are initiated, can it not?
no, we wouldn't file. There's no abandonment until actually we file for an appropriation. We abandon the proceedings by, dismissing the case. If we send the landowner a letter, that's not a proceeding. We cited the case Cleveland Cold Storage that very clearly
Okay.
says the proceeding begins with the lawsuit. So when we walk away from the lawsuit, we need to have some certainty under the statute of what that means. Here, there is no way for my client to have predicted that taking half a parking lot for which we value $200,000, we would get a bill for nearly $400,000. Had we anticipated that, we would have tried the case. Heck, we'd at least have gotten something out of this litigation, or at least gotten it to the jury for a few $1,000s more and then decided. There is no mechanism for my client to be able to take the deposition of the landowner and figure out what other expenses my client is going to face under the statute. And that cannot be reasonable, Your Honor. It simply can't. I can anticipate aerial footage, drones, I can anticipate computer animations, I can anticipate lots of things that landowners are going to put in front of me. I couldn't have anticipated that Mr. Albee is going to offer these, in his words, generous retirement bonuses. And it also gets mixed in with whether it's part of his retirement or his not retirement. I think that part is sort of a red herring to this whole thing. The issue is very clear whether an employee retention bonus is going to be an other actual expense. We believe that the seller's test of pretrial litigation expenses, whether it's the triplet test of reasonably necessary for the preparation, those are the things that this court can adopt and inform other courts of how to apply 163.21a. If we move into 163.21.6.
Can I ask a quick question? When
Yes, ma'am.
when we're on the record, when were the retention bonuses offered? Was that before or after the lawsuit was filed?
It was, so the retention bonuses, to be very clear, was in December of 2016. The lawsuit was filed in June of 2018. So we're talking a year and a half later. 6 months after the retention bonuses were issued, ODOT notified the landowner that it was not taking the building, that it was only taking part of the parking lot. As a consequence, there was no change in the severance policy because under their theory, they would still not have a functioning business. It's kind of irrelevant, but there is a gap of at least 18 years between that time and the filing of the lawsuit. And then there's another 18 years between the time of the filing of the lawsuit and when we abandoned in December of 2019. So, but I don't think the court has to get too wound up in the facts, because take employee retention bonuses for whatever they might be, regardless of what he categorized them for. Our position would be that even if he had a proper email after the filing of the appropriation, we would not be paying an employee retention bonus. It's not related to the litigation. It's not in connection with the proceedings as the statute had talked about, or in the prior version, in the conduct of the proceedings. That provides no test for lower courts to be able to apply. It puts my client and every acquiring agency in the unknown situation of having to abandon with no concept of what they're going to be facing, and no way of discovering it too, because remember, under the civil rules, I can only ask those things that are reasonable for the anticipated admission of evidence at what? A trial about value of land, not about the value of the abandonment. It puts my client in a way that we have no idea. The statute has to be read in a mechanism that my client can effectuate it. And I don't want to leave the displacement statute alone. That one talks about costs, disbursements, and reimbursements for what? Attorney's fees, engineering fees, and appraisal fees. But yes, I would concede that that statute does not include the words displaced persons. But I think owner has to contemplate displaced persons. And the reason is because the last part of that paragraph says, as provided for, and then it says 9G and 21A and 21C. Well, if I'm already providing it somewhere else, this statute has to add something to it. And that something to it is displaced persons. It's in the section talking about displaced persons. Even in the absence of the word, owner can only mean that because otherwise I'm paying for it somewhere else. This statute would have no meaning if it's replicating what appears somewhere else. I would also remind the court that in Capolozzo 2, which is the one that was decided in 2003, this court, talking about this specific statute, said, and I quote, as usual with the revised code, it is poorly drafted. So the idea that these words can't be interpreted, can't be refined, can't be understood on a statute that this court has already said is poorly drafted confines my client to something beyond what this court has already told me is already a poorly drafted statute. But even as poorly drafted as it is, we do have the ability to say someone has to interpret it. Someone has to give it meaning. And in 2007, the Legislative Service Commission, when they looked at the entire chapter, we looked at it and said 163.62, that is for displaced persons. And that's the way the Willoughby versus Slyman 11th Appellate Court looked at it. That's the way the Toledo versus Bernard Ross Family Court looked at it. They said, if you're not displaced, then this statute doesn't apply. And I know that my friend on the other side is going to say, or at least he put in his brief, oh, well, those aren't state agencies. And he cites the statute. Well, the problem is he didn't cite the entire statute. The end of 163.51A says any person with the authority to acquire property, any person. And 2 sections later, it defines person as any corporation. Municipal corporations are corporations under the law. Cities of Willoughby, City of Toledo, they are in fact acquiring agencies as a state agency, and therefore Willoughby and the Toledo cases are applicable to this decision.
Thank you, Attorney Cordero. Unless
Thank
there are any other questions from the panel. Okay, thank you for your time this morning. Attorney Callan.
Thank you, Judge. Just a couple of comments here. First of all, this idea that the email from Raiders came out before the complaint was filed and before this change in the scope of the take. It's been my client's consistent contention from the beginning that the reduction in the scope of the take still made the residual of this property unusable as a commercial record center. We have multiple expert witnesses that would testify to this. We had land use experts that would testify the residual was largely unusable for any purpose. So the idea that this somehow transformed from a complete take to a partial take of a parking lot is just not so. I mean, you have to have some understanding or sensitivity to the operation that is going on in this building. And it's a commercial record storage center, which means its clients give it vital records, irreplaceable records, and those records must be saved and they must be retrievable on demand, which is a service my client provided. That can't be done adjacent to, a high-speed exit ramp onto a highway. Secondly, when Mr. Cordero talks about the kinds of expenses that he and ODOT and courts have viewed as appropriate that might be other actual expenses, he talks about soil testing and water testing and these kinds of things. Well, so the problem with that analysis is that he's talking about the fee simple property owner and the interest being taken by ODOT from the fee simple owner. And in this case, the building owner is Albee Holdings. The appellant biz is the operator, it's the tenant. So it has different kinds of expenses. It has operational expenses. It has moving expenses. in moving expenses in particular are clearly covered by the statutes. And this is just another expense that is similar to a moving expense. So maybe it's not similar to, soil and water testing, but that's fine. But the interest that we're talking about is the tenant and the operating business interest, not the fee ownership interest. So it's very different in that sense. Looking at the, and I'll say this wrong, but I think it's Capolozo, I think. Looking at that case, I think it was Judge Painter pointed out that as usual, the statutes are poorly written. Well, again, remember, these are remedial statutes. So if there's any doubt about what that statute means, which according to Judge Painter there is, then that doubt should be resolved in favor of BIS. It should not be resolved in favor of ODOT, as ODOT is not the party benefited by the remedial nature of the statute. A lot of Mr. Cordero's arguments seem to revolve around the idea that ODOT could not have anticipated this kind of expense. ODOT never served discovery about this kind of expense, and that's one thing. I mean, clearly, BIS would have made this claim at court in trial. It's an expense that it incurred and expected to be reimbursed by ODOT. So just because they didn't serve discovery about it doesn't mean that he couldn't have asked about it. He also, if he was thinking about abandoning it, he could have called me up and said, hey, what do your fees look like? What are your costs? What kind of expenses do you think you have here? And we could have had that discussion before the abandonment. So it's not like there is no remedy, no way to find out what these claims might look like. Really, when you think about this idea of being, foreseeable or whatever Mr. Cordero thinks is wrong with this claim, I mean, in the absence of these statutory claims, BIS would be making an estoppel claim, a common law. So, it's not just whether or not the statute allows it. I mean, Mr. Rader sent the email. ODOT told BIS that it was going to take the entire property, told Albee Holdings the same thing. I mean, there are estoppel arguments here that may be successful, but the idea is we're now in a taking footing. So we have statutes and remedial statutes at that cover these exact kinds of questions. And
I understand that they want to treat their employees well, but they didn't, after the taking was abandoned, they were not on the hook to pay the retention bonus, were they?
They felt that they were, and I think
but they weren't, though. They could have said to the employees, hey, there's no taking, we're not moving.
Well, a couple of things there. First of all, I think the way that policy is phrased, I think that it did create a legal obligation to make that payment. Second, I think there would be a very good estoppel argument. This exact case came up in the Village of Amelia out in Claremont County. You may remember that the Village of Amelia was threatened with a dissolution proceeding, and it was going to the vote. And in order to keep village employees on staff, Amelia offered them retention bonuses. That it's the exact same situation. You have an uncertain future and retention bonuses are offered. Amelia didn't pay and the employees sued. So I do think that there is a very good chance that there's a legal obligation there. And like I said, at least a reliance argument and an estoppel argument. Not to mention that if a business owner failed to make good on a promise like that, you would have very unhappy employees going forward. And again, these employees are vital. They're vital. Unless there are further questions, Your Honors, I believe I've addressed what I wanted to talk about. Thank you.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission, issue a timely decision, and we wish you both a wonderful afternoon.
Thank you. You too.
Thank you, Your Honor.
Yeah, no.
Good morning.
Good morning.
We're here now on case number C210113, Cincinnati City School District Board of Education versus City of Cincinnati et al. If attorneys can please identify themselves and their readiness to proceed.
Yes, my name is David Demuzio. I'm the attorney for the appellant. I'm ready to proceed.
Good morning.
Your Honor, my name is Russell Sayer, representing the appellee, and we are ready to proceed.
Good morning. Attorney Demuzio, would you like to reserve time?
Yes, I'd like to reserve 3 minutes.
3 minutes, whenever you're ready.
Thank you. May it please the court, this case is relatively simple. The main issue is this simply a run-of-the-mill appeal where there were competing appraisals of the Board of Tax Appeals? Both appraisals were given due consideration. Issues were resolved and reviewed, and a reasonable and thorough decision was issued. Or does it fall into a special category, which we think this one does, in which the Supreme Court has indicated that if the Board of Tax Appeals does not look at conflicting evidence on key issues, but simply gives a cursory review, talks about what happened, doesn't really deal with the main issues and with the conflicting evidence, especially when there's one appraiser who specifically discusses the approaches taken by the other appraiser, criticizes them, says they're improper. I don't think any reasonable person could review the 2 paragraphs in which the BTA discussed their reasoning behind their decision and come to any other conclusion but that this fits category 2. We know from the Lutheran Social Services case, it was only from 2017, that's what's supposed to happen, that the BTA is supposed to review conflicting evidence on key issues, and which would then allow this court to decide whether or not they acted in a reasonable and lawful manner. I just want to briefly read from, this is from page 2 of our reply brief, if the court wants to follow along, but we actually quote again the key case, which is the Lutheran Social Services case. And here's what the Supreme Court said in 2017. The BTA must engage, I stress the word must, BTA must engage in sufficient discussion of the evidence to permit the court on appeal to determine whether the BTA acted reasonably and lawfully. They go on to say it does need, it being the BTA, it does need to consider and weigh conflicting evidence in the course of justifying its reliance on certain evidence as opposed to contravening evidence. Nowhere in those 2 paragraphs do they do any of that. They simply say, we found the other guy better, and they move on, which is not permit this court to do its job. The parties agree on what the two key issues are. I was shocked when I read Appelli's brief. I got through the first 2 or 3 pages and I wondered, is this something I drafted? I urge the court to go back and read the first 2 or 3 pages, and you'll see that Appelli does an excellent job of explaining the 2 most important issues. They go to great lengths. They cite the transcript, and they tell us all about these 2 issues, which are, is the ability of the building to accept additional floors important enough to raise the value, and who did a better job on coming up with comparable sales for both land and buildings. And yet, when you review the decision, you see 0 discussion of those 2 important issues. So it clearly falls in the category of that special mandate from the Supreme Court. The Appelli provided last week a supplemental case called Healthcare REIT, and I want to talk briefly about that. That case actually falls into the first category. There was, basically a sore loser. There were competing appraisals. The BTA reviewed them. The loser appealed, and the court said, look, they did a sufficient job. First of all, that case was 2014. Ours is 2017. But more importantly, we went ahead and printed out the case, and I urged the court to look at page 18 of the Supreme Court decision in the Healthcare REIT case. And in that top paragraph, which is paragraph 58, the Supreme Court talks about the detailed analysis that the BTA did of the losing appraiser. They talk about, the BTA explained that Mr. Rasick's valuation was more persuasive than Ridley's. They talk about how Ridley did not adequately distinguish the business components, et cetera. They go into all sorts of detail about why the losing appraiser's appraisal didn't do a very good job. We see none of that in ours. We see passing references to our appraiser, Mr. Burt, to what he did, but little or no, or actually no discussion of the conflicting evidence between the two. Now, why is this important? Mr. Thornton, who was the appraiser for the winning side, he used land comps. Let me just quickly let you know the sort of land comps he used. And keep in mind, he's comparing it to Fifth and Vine, the most attractive for development situation in downtown Cincinnati. He picked Central Parkway for his land comps, Pete Rose Way, Fifth and Plum, 8th and Main. Just gives you an idea on the land comps. On the building comps, he picked a series of buildings with ages ranged from 1903 to 1916. 1916 was the newest case that he had come up with. The subject property was built in 1997. As I mentioned, it's in a prime location. The buildings that Mr. Thornton picked were the Gwynn Building at 6th and Main. The former Frisch's, I used to eat there years ago. That's the one where you had to go down in the basement at 4th and Main to get to the Frisch's restaurant. He's using that building to compare to the premier location spot there where the Macy's was. As I mentioned, the original ages were 1903 to 1916 for Mr. Thornton, and the subject was built in 1997. None of the comps could accept additional floors like the subject could. The subject was built for the specific purpose of accepting additional floors because they felt that what was there, the 3-story structure, was really an underutilization back at the time in the late 90s. And they felt that certainly in the future, somebody would want to put a much larger and more impressive. And so that's why they did the super.
That's where there was the difference in the testimony. There was testimony that this would have been dangerous and that it would not be appropriate to put additional floors on this building, right?
Yeah, that came from Mr. Geltner, who obviously is interested party. He's with 3CDC. They're the ones that would have hoping to get the tax reduction. What's interesting is he never produced a report. He just said that as an interested party. He said we had studies. But most importantly, that came up, that was done after they owned the property for about a year and a half. When you're in these real estate cases, we're talking about a 2018 value. What did the marketplace know? What did the marketplace? 3CDC bought this property before that review was done, but after the 2018 key date today. So that really isn't, and it's of course hearsay for them to bring that up. We never saw a report. Keep in mind, they had the burden of proof. They had lost at the Board of Revision. They appealed to the Board of Tax Appeals. So the city had the burden and the 3CDC had the burden. And to come forward and make those kind of, which you've pointed out, important accusations, and based on speculation, based on hearsay, simply wasn't fair and, should not be considered. And even if it's true, even if they found cracks or defects in 2019 or 20, what does that matter? It's speculation to assume that some buyer would have been aware of that. I did want to talk on the issue before I leave the issue of comps. Appellee criticizes us in its brief, criticized Mr. Burt, and they say, well, Mr. Burt ended up at the higher end of the range of its comps, and Mr. Thornton ended up in the middle, and doesn't that mean Mr. Thornton is more reasonable? Remember, not only are Mr. Thornton's comps on the edge of downtown, Central Parkway, Plum Street, but they're 1903, 1916, and they can't accept additional floors. Does it make sense to end up in the middle of those comparables? Or does it make sense, being the premier location in downtown Cincinnati, being a 1997 vintage building, that Mr. Burt's correct in putting it at the upper end of the range? I mean, we were shocked when we saw the decision. I mean, if you had read the evidence and seen the case,
what you're asking us to do as an appellate court is to make some ruling saying that they have to get into more detail. I mean, clearly they acknowledge that there's two experts, two different appraisals, and they picked one. And what I'm trying to understand as a court of appeals is what kind of ruling are you seeing out of our court?
Right. What I'd like you to do is do what the Supreme Court mandated in the Lutheran Social Services case, which is it should be remanded. The court, the BTA is certainly allowed to come back, after remand and review these key issues. But
But Lutheran, they didn't even address the competing appraisal in Lutheran, right? Wasn't that the problem?
Oh, yes, and the same exact thing happened here. Mr. Burt's appraisal was not addressed. It was mentioned, and they simply said, we like one more than the other. Very almost identical situation to what we have here. And then the other thing too is we talk about in the additional errors. This case is a real mess. They do briefly talk about why they decided on Mr. Thornton. They say, well, he did a better job of dealing with the cost of demolition. Well, the property is not going to be demolished. It's still sitting there, by the way. If you've driven by there, it was not demolished. There was no intention. Neither appraiser thought it should be demolished. It made absolutely no sense. They cite Mr. Geltner for the proposition that it should be demolished. We deal with that issue extensively in our reply brief. Mr. Geltner said nothing like that. He said it was an option they looked at. They could have looked at 27 options. They chose not to tear it down. So, we don't know what was going on, but it's very clear, even if we didn't have this Lutheran social service issue, this was based upon evidence that wasn't in the record, that had nothing to do with the case. They also allege when they do reject Mr. Burt, they say that one reason was they thought that Mr. Burt did not use the same data or have access to the same data that Mr. Thornton did on the issue of the cost of demolition. Again, please read our reply brief. You'll see that's simply not true. He had exactly the same access, used exactly the same data. The appellee deals with this in their reply brief by basically defaulting. They don't deny what we said. They say, well, he did deal with the issue of demolition costs on the comparable sales, but that's a whole totally different issue than the issue that the court decided the case on. So again, we feel that no reasonable person could review those two paragraphs and come to that conclusion. I'm sorry.
You're muted.
I couldn't hear your question. I'm sorry.
I am sorry. You have about 1 minute left and I'll be reserving you 3.
Actually, that's all I have. If I could reserve the rest of my time.
Okay, thank you.
Thank you.
Good morning.
There. And can I be heard, Your Honor?
Perfectly.
Okay,
Whenever you're ready.
I'm ready. Good morning again. May it please the court. We do agree on one important thing. This is a straightforward, fairly simple case. A straightforward appeal of a Board of Tax Appeals decision, the sort of case that this court has seen many times before. And as is often the case, it does not present the court with a particularly close call. The issue presented is the usual one, whether the BTA properly exercised its discretion, weighing the evidence and assessing the credibility of witnesses in connection with the valuation of the old Macy's building on Fountain Square. Faced with two competing appraisals using similar methodologies, but with the city's appraiser, Mr. Thornton, relying on more data, the BTA weighed the testimony, weighed the evidence, and adopted the appraisal that it determined was the more reliable of the two, the city's. It's that simple. Now, for decades, recognizing the expertise that the BTA brings to these matters, Ohio courts of appeal have afforded the specialists who make up the Board of Tax Appeals a great deal of deference in making their decisions about real estate value determinations. One Ohio Supreme Court decision, from this one from 2016, put it succinctly like this, and it's a short quote. Quote, if the parties present competing appraisals at the BTA, the weighing of evidence and the assessment of credibility are the statutory job of the BTA, and that body is vested with wide discretion in carrying out that function. And that's the Board of Education versus City of Westerville. This is a similar case. As to the old Macy's site, the Board of Revision adopted the auditor's $19 million valuation. And so the parties wound up in front of the BTA with the school district defending the BOR decision and the city seeking a lower valuation. And from there, I think the hearing took place in the normal way. The city offered evidence from two knowledgeable witnesses, including an appraiser, Mr. Thornton, whose qualifications were stipulated to. And as it turned out, the BTA agreed with Mr. Thornton, who had valued the property at just a shade under $11 million, $10,990,000, and it rejected the valuation offered by the school district's appraiser, James Burt, of $16.73 million. Now, it is interesting that the appraisers agreed with one another on several broad issues. They both agreed that the Fountain Square site was underutilized. They both agreed that the three-story structure would have to be redeveloped to achieve its highest and best use under the circumstances. And they both agreed that the underground parking garage beneath the building was worth $4.1 million. So the dispute centers on the above ground portion of the site itself and how it should be valued. And even there, the similarities in the appraiser's methodological approaches were quite similar. Both rejected the income and cost methodologies as unsuitable, and both used a sales comparison approach. They each selected a number of comparable properties. Mr. Thornton examined 6, Mr. Burt examined 4. 2 of them, I think, were the same buildings. But at the end, the work of the two appraisers diverged, with Mr. Thornton's valuation coming in at the $11 million figure and Mr. Burt's at the $16 million figure. And the main source of the disagreement there was whether extra floors could practically be added to the existing structure. So in addition to Mr. Thornton's testimony, the city presented the testimony of Adam Gelter, no N, an executive with 3CDC who testified for the city and provided some of the factual underpinnings that informed Mr. Thornton's work. Mr. Gelter testified in part based on the results of engineering studies and other factors that further construction of multiple floors was impractical for a host of reasons, including costs, building code issues, the footprint of the building, its the north side being blocked by another building, the footprint of the building, and the practical difficulty of having heavy construction equipment in the Fountain Square area. So Messrs. Thornton and Gelter essentially saw adding multiple additional floors to the structure not only impractical, but really functionally impossible. So in other words, Mr. Gelter offered strong corroboration for Mr. Thornton's valuation of the property. And in the end, the BTA adopted Mr. Thornton's valuation over Mr. Burt's because he had better accounted for the value of the site and the cost of the necessary demolition and redevelopment. And on that point, I want to talk for just a moment about demolition. I think this business about neither appraiser favoring demolition is the product of a misunderstanding of sorts, although not on the BTA's part. Demolition was always going to be necessary with this structure, though tearing the entire structure to the ground level obviously is not and was not. In fact, the demolition process is underway right now. You can look out my window and see it. The misunderstanding, I think, is that the owner can, and in this case must, do quite a lot of demolition on the structure, but you don't have to raise it to the ground when you do demolition. And that's the situation here. The building, the shell, the concrete shell will remain. Both appraisers assume that. And the rest of the improvements will be or have been demolished. Now, I think implicitly acknowledging that the BTA did its work correctly, the school district is urging the court to adopt a sort of a new and unprecedentedly stringent standard of review that has not been adopted, I think, by any Ohio appellate court or the Supreme Court. Essentially, I hear the school district arguing that the BTA should have issued findings of fact, conclusions of law, addressing all the parties' competing arguments. And the school district complains that the BTA did not give specific and detailed consideration to each and every one of the arguments made by the parties. But the fact that we are arguing about the facts here, I think, is ample confirmation that we know exactly what the BTA did and why it did what it did. In the cases cited by the school district, the Lutheran case in particular, that was not the case. The problem generally in those cases is that the courts could not tell what the BTA had done or relied on, and we simply don't have that problem here. We have a record, we have a decision, we all five know exactly what happened, we know what the facts are, we know what was considered. The Court of Appeals does not have to act and should not act as a sort of super BTA, and fortunately that's a task that is has not been put before you. The BTA was not required to do anything more than it did. It had only to say what evidence it relied on, and it did just that by explaining why it found Mr. Thornton more persuasive, and that's enough. The Ohio Supreme Court in Healthcare REIT, for one, found it sufficient for the BTA to simply say, we find one of the appraiser's opinions of value more persuasive. But the BTA did considerably more than that here. And before getting to its analysis, the BTA recited much of the evidence it had heard from Messrs. Thornton, Gelter, and Burt. It remarked on the points of agreement between the two professional appraisers in terms of methodologies and even on the value of the parking structure. And then it explained that it was adopting Mr. Thornton's appraisal of the surface structure over Mr. Burt's appraisal because Mr. Thornton had better accounted for the cost of the demo and redevelopment. He considered data that Mr. Burt did not, and Mr. Gelter's testimony tended to corroborate Mr. Thornton's conclusions and appraisal. So what happened? The BTA simply determined that the city's appraisal was the more reliable of the two. As for the school district, the testimony it offered from Mr. Burt and only Mr. Burt was simply less comprehensive, based on less reliable information, and just plain less information than Mr. Thornton's. Mr. Burt's opinion that the building was worth more because floors could be added, flatly contradicted by Mr. Gelter, was based on what he testified, transcript page 119, transcript of the hearing. His conclusion that additional floors could be added was based on what he called common knowledge, nothing else, no other evidence. Mr. Geltner had specific reasons why additional floors were not practical. Mr. Burt did not address, let alone contradict Mr. Gelter's testimony about the impracticability or perhaps impossibility of adding new floors. And all he did with Mr. Thornton's report was skim through it. So he has nothing to say about that. This being the case, it comes as little surprise that the BTA adopted Mr. Thornton's appraisal. The city offered the greater amount of evidence, the more relevant evidence, and a better informed appraisal than the school district did. And so it is little wonder that the city prevailed. It is little wonder that the school district is urging the court to depart from decades of settled practice and adopt a new and far more stringent standard of review that would impose huge burdens on BTAs in this county and throughout the state. The court should decline, I think, to substitute its own judgment for that of the BTA or second guess its decisions. And I will close with a quote from the Supreme Court. EOP-BP Tower versus Cuyahoga County Board of Revision, quote, the BTA has wide discretion to determine the weight given to evidence and the credibility of witnesses before it. That's what the BTA did here. This is the standard established by the Supreme Court, and this is the standard that is routinely applied by Ohio appellate courts. Now, I say I have some more time, but that concludes my presentation unless the panel has questions.
Thank you for your argument this morning.
Am I up on rebuttal?
You are.
Thank you. counsel began his oral argument by quoting from a Supreme Court case in which he again tries to characterize what we're doing as simply a battle of appraisers. And he quotes the Supreme Court where they talk about how they're going to give great deference to the BTA. But please pay attention to the end of that quotation. I wrote it down. It said, great deference should be given, quote, in the BTA carrying out their function. And that's what we're arguing about today. Have they carried out their function? Clearly, we should give great deference to them if they do their job. If they don't do their job, that's why we have Supreme Court. That's why we have Court of Appeals to say, we'll give great deference to you, but boy, you really need to do your job. You need to deal with the two important issues and certainly not deal with issues that have nothing to do with the valuation of the property. And that's really what's happening here. You can tell from the argument that the appellee is desperate to convince you that this falls in that first category I mentioned of just a sore loser kind of a situation. But clearly it's not. Again, I began my argument by reading from the Lutheran case, talks about the need to deal with conflicting issues. No reasonable person, I didn't hear him, I didn't hear counsel tell us where in the world in those two paragraphs that happens. 100% clearly falls within the Lutheran case of special situations. But how desperate are they? Well, part of the argument was that they say that the school board really just wants you, is trying to get you to insist upon findings of fact and conclusions of law. Again, not true. We said that in our brief. We've said it in our arguments. We simply want this court to apply the Lutheran narrow case law, which says that you must at least deal with these conflicting issues. Lutheran itself says there's no need to deal with each and every issue. There's no need to give a set of factual findings. We're not asking that. We're simply saying on the two important issues that we think that everybody agrees are the important issues that should determine the outcome, is it really asking too much that they do their job? So yes, you should give.
So that would be what you would ask us to put in a remand order?
Yes, put a remand order in saying they must deal with these two issues and they must explain, what in the world this cost of demolition has to do with a property that neither appraiser wants to demolish. I mean, again, on its face, and to ask them to look at this false accusation that Mr. Burke did not use that same information when the record clearly indicates that he did. This issue of the inability of the building to accept additional floors. Both experts said that the marketplace felt and understood that new floors could be issued. That's the issue in market value. What did the buyers know in 2018? What Mr. Geltner came up with a year and a half later is of zero relevance. Those cracks, those problems could have arisen after 2018. It's pure speculation and innuendo to assume that was there. And if that was the reason the board ruled like it did, why didn't the board say so? So again, what we're asking is that this be remanded, that they be asked to do their job, under the Lutheran case, and so that this court, if it comes back again, can soberly and reasonably decide whether or not they dealt with those two most important issues. Thank you.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission, issue a timely decision, and wishing you both a marvelous afternoon.
Thank you.
That concludes